Today I want to discuss with you one of my favorite cases, the DuPont de Nemours case from 1979. And the reason why this case is my favorite, or one of my favorites, and why it should be famous is because it is a case where the so-called Berry ratio was first used by the IRS to win a tax case as an example of what the 482 regs, which is the US transfer pricing rules regulations, at that time called the fourth method. Now, the decision is from the United States Court of Claims, and we will go through it. It's not very long, it's 20 pages. Unfortunately, I could not get to the underlying decision. You can see in the first note of this case, I talk about we adopt with minor modification Trial Judge Willie's findings of fact. I really would like to be able to read Trial Judge Willie's decision because I think it will tell us a lot more about the Berry ratio than the appeal case does here. But I don't know. But I don't have that. If anyone has that, please send it to me. I would much appreciate that. To make up for the lack of the underlying case, I do have an article on Berry ratios, their use and their misuse by Charles Berry himself. And we will go through some of the comments that he makes about the Berry ratio as we go along. This article has been published in the Journal of Global Transfer Pricing in 1999. I got it through a library exchange with a Copenhagen library. And as I said, we will comment as we go along. So let us start by looking at the facts of the case. We've got the US, and then we've got Europe and the rest of the world. And then you have DuPont. And then in 1959, they created a wholly owned Swiss marketing and sales subsidiary for foreign sales. And this was called DuPont International S.A. or DISA as they call it in the rest of the case. Most of the DuPont chemical products marketed abroad were first sold by the taxpayer to DISA, which then arranged for resale to the ultimate consumer through independent distributors. So the structure looked a bit like this. You had the UK company, we'll get to that in a moment. Then you had sales destined for the EU, South Africa, and Australia. We'll get to that in a moment. And then you've got sales that went from DISA to the EU, South Africa, and Australia. Now, the issue was for 1959 and 60, the Commission of Internal Revenue found the division of profits between DuPont and DISA to be economically unrealistic. So he reallocated a substantial part of DISA's income to the taxpayer. DuPont paid this and then appealed the case. Now, what is interesting is that the court very clearly says neither in the planning stage nor in actual operation was DISA a sham entity, nor can it be denied that it was intended to and did perform substantial commercial functions which the taxpayer legitimately saw as needed. However, then they go on to say, nevertheless, we think that it also is undeniable that the tax advantages of such a foreign entity were also an important consideration for DISA's creation, and we will see exactly how important it was. The court also constituted consistently with the tax-saving aim. Plaintiff's prices on its intercorporate sales to DISA were deliberately calculated to give the subsidiary the lion's share of the profit. DuPont left the pricing on the sales to DISA with the Treasury and legal departments. Neither department was competent to set economic value on goods sold to DISA, and no economic correlation of the cost to prices were attempted. An official of the Treasury Department established a pricing system designed to leave DISA with 75% of the total profits. However, for 1959 and 60, the actual division of total profits between plaintiff and DISA was closer to a 50-50 split, and that was because the Treasury Department got the calculations wrong and omitted certain intercorporate transfers. DISA had certain economic advantages. For instance, for its technical service function. It did not develop its own extensive laboratories, but could rely on its parents. It wasn't required to hunt extensively for qualified personnel because it got those from the parent. And the credit risk was very low, in part because of a favorable trade credit timetable by DuPont to DISA. DISA also selected its customers such that it avoided credit losses. In operating DISA, DuPont also maximized its subsidiaries' income by funneling a large volume of sales through DISA, which did not call for large expenditures by the latter. Many of the products DuPont sold through DISA required no special services. DuPont routed sales to Australia and South Africa through DISA, although the latter provided no additional services. DuPont also routed all European sales of elastomers through DISA, even though the parent had a well-established UK subsidiary. So DuPont UK would also sell to DuPont International, who would then sell to Europe and the rest of the world. And then the court ends with a rather sweet sentence as far as the facts are concerned. It says, "It's not that there was anything illegal or immoral in DuPont's plan. It's simply that that plan made it very difficult to satisfy the controlling Treasury regulations under Section 482. Now, we need to remember that this structure was set up in 1959, right? So tax morale at that time was very different. Nonetheless, I think it is interesting to read some of the things that the court have discovered, which I think today would cause an absolute outroar. And the court seems quite calm about this, and DuPont is even prepared to continue fighting the case in spite of the court knowing this. So if we look here at footnote 4, it says DuPont is divided in a series of semi-autonomous departments which report to the executive committee. An early draft of memorandum in this subject to the executive committee from the international department stated that the Treasury Department, also responsible for DuPont's tax planning, was responsible for the possibility of a transfer of goods to a tax haven subsidiary at prices less than such transfers would be made to other subsidiaries in industrial departments. That is bad enough of itself. But then it says, a memorandum from the Treasury Department reviewed the possibility of an IRS attack on such pricing method and concluded, it would seem to be desirable to build a tax haven subsidiary at less than an arm's length price. There, you've done already today, right? You have already documented you're not using the arm's length price. But listen to the reasoning. Because one, the pricing might not be challenged by the revenue agent. Two, if the pricing is challenged, we might sustain such transfer prices. In other words, we might win in court. And three, if we cannot sustain the prices used, the transfer price will be negotiated, which would not be more than an arm's length price and might well be less. Thus, we would be no worse off than we would had we been billed at a higher price. So, a no-lose situation. Let's go for the most aggressive tax planning that we can possibly implement. But it doesn't surprise me so much that this was what was written into memoranda back in the 60s. What surprises me is that it comes to court and you still fight the case with dry eyes, pretending that your prices are indeed by luck at arm's length. Let's look at what DuPont has argued, because they first leaned towards a resale price method. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Now, the taxpayer argued that they were using the resale price and that was one of the acknowledged methods and therefore things were fine. But the court did not buy that. And here is basically the summary. The taxpayer tells us that a group of 21 distributors whose general functions were similar to DISA's, i.e. they were distributors, provides a proper base for comparison. But there's nothing in the record showing the degree of similarity called for by the regulations, that's the 482 regs, right? Rather, the record suggests significant differences. Defendant, who is the IRS, introduced evidence that the 6 companies plaintiff identifies as most closely with DISA all had average selling costs which were much higher than DISA's. Okay, so they might have had the same kind of profits, that's why they were chosen, but they also had costs which were much higher. And we're slowly working our way towards the Berry ratio here, right? We agree that what a business spends to provide services is a reasonable indication of the magnitude of those services. And we cannot view these 6 companies as having made resales similar to DISA's. They may have made gross profits comparable to DISA's, but their selling costs were much higher in each instance. Moreover, these companies dealt with quite different products, electronic and photographic equipment, and functioned in different markets, namely the US. And remember, we're talking about the time when the European community, not the EU, but the EC was kind of just coming together. And that is why DuPont set this company up in Switzerland to make use and to benefit from this internal market and the freer flow of goods. Or let me rephrase that. That's also why DuPont set up DISA. But after this first attempt failed, the taxpayer also comes with a second argument as to why the resale price should be used. They say we are cited to the gross profit margin contained in the Inland Revenue Service Source Book of Statistics of Income for 1960. Because the gross profits for this group of undisclosed companies in 1960s was on average 21%. And the taxpayer infers that DISA's gross profit of 26% was reasonable. But the court says again, the lack of any data precludes any such conclusion. The fact that, and I think the court says this rightly, the fact that within the wholesale category, gross profits varied from 9 to 33% indicates that to take a mere arithmetic average without considering the underlying factual details would risk a total distortion. And you know, it's easy with looking back at this case with today's mind to think, my God, don't they realize how important the facts were? But remember, we're talking 1959 and 60. Remember that the new at that time 482 regs were actually only published in 68, and the reason why they used the 482 regs was because they had retroactive effect. Yeah, so the world was a lot simpler in those days, but that doesn't make this a less interesting case to have a look at. And after some further consideration, the court shoots down the resale price method by saying the upshot is that the plaintiff had failed to bring itself within the resale price method. The record before us does not support use of that formula for this case. We have to conclude it's not possible to apply the resale price method, and this opened the case for using another method. So there were no cups, they were not going to apply the cost plus. Actually, in fact, the Berry ratio is a type of cost plus, but that's not what they concluded. And the resale price didn't work simply because DuPont couldn't show comparability, and to the extent that there was comparability, but there needed to be comparability adjustments, DuPont was not able to come up with the required comparability adjustments to make the cases more comparable. And then we get to what the alternative methods were that were used.